legal counsel for the Registered Massage Therapists Association of British Columbia. And on this video today, I'm going to be talking to you about your professional duty to report as a registered massage therapist in the province of British Columbia. The professional duty to report is, it's not a fun topic, obviously, and I've heard it referred to variously as thinking on fellow professionals, and I think it's important that as a profession that you not consider it to be something that is unethical or looked down on by your fellow professionals. Your profession is no different than my profession, the legal profession, which is in turn no different from the profession of doctors. It is important for those of us who are members of this profession to maintain and preserve the integrity of the profession in its entirety, and that is in fact where the duty to report arises from. It is not a duty that should be exercised lightly. I think that goes without saying, but similarly it is not a duty that should be ignored when the appropriate circumstances arise. All right? So initially I'm going to deal with the obligations that arise under the Health Professions Act of British Columbia. Then I'm going to talk about the obligations that arise under the college bylaws. And then lastly, I'm going to talk about the obligations that arise under one or two other miscellaneous statutes in British Columbia. So first off, the Health Professions Act. There are some very specific duties to report that every person who practices under the professions registered on the Health Professions Act, which includes doctors and registered massage therapists, physiotherapists, chiropractors, etc., have an obligation to do. All right? And the first one is if the public is in danger due to an impairment. The Act requires you, as a massage therapist and a registrant under the Act, to report a fellow RMT to the college if that RMT, in your reasonable belief, is not competent or suffering for a physical or mental ailment, emotional disturbance, or an alcohol or drug addiction that impairs their ability to practice. You have to have a reasonable belief that the public is in danger if that person continues to practice. In that circumstance, you have a positive duty to report that individual to the college, the chair of the inquiry committee. All right, the next obligation under the Health Professions Act is when you believe, again, you have a reasonable belief, that a danger exists to the public and that danger results in the termination or would have resulted in the termination of that registrant as a result of their conduct. If you reasonably believe that the continued practice of another registered massage therapist constitutes a danger to the public, and because of this continued practice, that registrant's employment is terminated, or their privileges are revoked or suspended, or their ability to practice is restricted, or if they're involved in a partnership that is ultimately dissolved as a result of their conduct, that in and of itself creates a positive duty for you to report that circumstance to the chair of the inquiry committee for the college. Similarly, if those circumstances arise, but that individual either resigns before action can be taken or dissolves the partnership before action can be taken, you still have a positive duty to report that individual to the chair of the inquiry committee. All right, the next obligation that arises in the Health Professions Act is one that also arises in the college bylaws, and it's one that's well known to everyone, and that's circumstances of sexual misconduct. If you reasonably believe that another registrant has engaged in sexual misconduct, you have a duty to report that individual. But here's the kicker. If that concerns sexual misconduct with a patient arises from information given in writing or stated by a patient, you must first obtain the written consent of the patient before making that report. That's important. If you make a report about that supposed sexual misconduct based on either an oral or written statement given by the patient without the patient's consent, you'll have end up on the wrong side of the requirements of the statute. So the statute also now requires that you make any complaint about another registrant in writing. And the important thing that you need to understand, and this is where the positive duty to report arises from, is that your failure to exercise your duty to report as it's set out in the statute could well result in a complaint against you made by another registrant or by the college itself if it later learns of your failure to report what you knew at the time. The last point that arises under the statute that everyone should be aware of is that if you make a complaint to the college about a fellow RMT and you make it in good faith, the statute expressly protects you from any cause of action by someone, even in the event that you're wrong, again, provided the complaint is made in good faith. If it can be established by the complainant that you made the complaint in bad faith, that is, it was motivated out of something other than strict obligations of what you consider to be professional obligations, then under those circumstances, that protection may not be available to you. All right, now moving on to the second source of the positive duty to report for professional RMTs in British Columbia, the college bylaws. These are probably more well known to most registrants because this is probably something you hear about on a more regular basis. However, it obviously bears repeating, and there are some, of course, that you may not be completely familiar with. So, the college bylaws state that you, as an RMT, have a duty to report another registrant if you have reasonable grounds to believe that any of the following have occurred. If another registrant has committed an act of professional misconduct. It's not a defined term, it is a broad term and it's intended to be a broad term. If professional misconduct, if conduct resulting to the level of what you feel is professional misconduct has taken place, you then have a duty to report that conduct to, again, the chair of the inquiry committee. If a fellow registrant has engaged in sexual misconduct with a patient or a former patient within 1 year of termination of massage therapy. Most of you will remember that from your classwork prior to your exams. Pretty straightforward. You can't be having sexual relationships with a patient or with anybody who was a patient within 1 year of them being a patient. I've actually, in my practice, had a question from an RMT at one point as to, well, if they wanted to do it anyways, what could happen to them? And I would urge you never to consider that as a reasonable question. Just don't do it. It's not about wondering what will happen to you if you do it. Just don't do it. The next point under the college bylaws, if you believe that a fellow registrant has practiced massage therapy while their ability to do so was impaired by drugs, by alcohol, by a physical or mental ailment, emotional disturbance, or addiction to any substance, you have a positive duty to report that. As you can tell, some of the wording in that specific clause is not perhaps as detailed as it might otherwise be. An emotional disturbance could be interpreted as being any number of things, and certainly a mental ailment, I would suggest that's probably a term that needs to be better defined. But I think the broader, more obvious conditions under that clause, such as drugs, alcohol, or addiction to any substance, query whether that means coffee, I'm not sure. I would suggest to you that it doesn't, but again, there is some wording there that is somewhat challenging to interpret. The point is, if you think there's a substance abuse problem, if you think that there's an impairment problem, and the impairment affects their ability to practice your profession, you have a positive duty to report. A further point if a fellow registrant has engaged in unsafe, unethical, or illegal activity related to the practice of massage therapy. That's an important distinction. If you happen to know, for instance, that a fellow RMT has a grow-op, this clause under the bylaws says it has to be unsafe, unethical, or illegal activity related to the practice of massage therapy. I would argue that under those circumstances, that wouldn't necessarily create a positive duty to report. The obligation here on you is to report another fellow registrant who has engaged in unsafe, unethical, or illegal activity related to the practice of massage therapy. It's really just a catch-all phrase that I think the important clauses here, frankly, are unsafe and unethical. And again, there's no specific definition of unsafe, no specific definition of unethical. It is something that you, as a professional, have to exercise your good judgment about. Again, provided that you make the complaint in good faith, you don't need to worry about legal recourse. But my recommendation, as is certainly the case that's followed in my profession for the most part, is if you're unsure, ask a colleague. Ask someone whose position in your profession that you respect and trust, and ask them whether they think that the conduct you're concerned about amounts to a breach of any of the provisions that are set out in the statute or the bylaws. The final provision that specifically is set out in the bylaws is you have a positive duty to report a fellow registrant who has permitted their office or clinic to be used for an unlawful purpose. And so, for instance, if you know someone that allowed their clinic to be used for the grow-op, then in that circumstance, the bylaws would catch them. All right, so you've decided that a fellow registrant has breached one of the criteria in the duty to report provisions in the bylaws or the statute. What do you have to include in your report to the inquiry committee? First off, it has to be in writing, and it has to be filed promptly. The bylaws do not require a report to be filed within a specific time frame other than promptly. I would suggest to you that if you wait for 6 months after learning the circumstances, that would not be interpreted as promptly. A week probably would. So, what do you have to include? You have to include the name of the person filing the report. That's you. You need to include the name of the RMT who is the subject of the report. You need to include the details of the alleged misconduct, the prohibited sexual conduct, the incompetence, or the incapacity. Again, if it has to do with sexual misconduct involving the patient, and it's based on either a written or oral statement of the patient, you have to have the patient's consent before making the complaint. Don't forget that part. You have to have the sources of information that you're relying upon. If you saw the conduct specifically, you put down that you saw the conduct specifically. If you are relying on hearsay from someone else about that individual's conduct, you have to put down that you're relying on someone else's evidence or statements with respect to the conduct in question. And if a patient is involved directly in the misconduct, you of course have to include the identity of the patient. So, we covered the Act, we covered the bylaws. Now there's a couple of miscellaneous statutes that also could, under certain circumstances, give rise to a positive duty to report on your part as a professional massage therapist. The first, and one that probably everybody has heard of, is the Child, Family, and Community Service Act, or the CFCSA. The CFCSA creates a positive obligation on individuals who learn about the circumstances of a child in need of protection to make a report to the director or a designate of the director. And the provisions of the Act set out, there's 12 separate grounds. I would recommend that, frankly, as a professional massage therapist, that you make yourself familiar with what those grounds are. But they include, for instance, whether a child has been or is likely to be physically harmed and or sexually abused, including by the child's parent, and under those circumstances, you have a positive duty to report, which, as you will recall under the bylaws, then creates a positive ethical and professional obligation on you to report as well. It's important for you to remember, under the statute, a child is anyone under the age of 19. That may be something to keep in mind if you have a patient, for instance, who's 18. I have an 18-year-old son that, to any and all outward appearances, is very much a man, and it might not necessarily come to mind that circumstances that he, for instance, would be in need of protection under the CFCSA. In fact, he would until he's the age of 19. Under the statute, the CFCSA, whether that information, and this is unlike the prior obligation to report circumstances of sexual misconduct with a patient, under the CFCSA, whether the information is confidential, whether the patient gives their consent or not, whether it's privileged information, you have an obligation and a duty to report that circumstance to the ministry. And if you fail to do that, you've committed an offense under the statute. Again, provided that your report is made in good faith, there's no action for damages that could lie. The other miscellaneous statute that under certain circumstances can give rise to a duty to report, albeit not a mandatory one, is the Adult Guardianship Act. And for those of you who aren't familiar with the Adult Guardianship Act, it is the statute that provides support and assistance to adults who are typically abused and or neglected, and because of a physical restraint or handicap, their ability to make decisions for themselves, and in particular about any abuse or neglect that they may suffer, is impaired. And the Adult Guardianship Act stipulates that anyone, obviously including registered massage therapists, who have information indicating that an adult has been abused or neglected, and they are unable to seek support or assistance, may report the circumstances to a designated agency. The reason I mention this one here is because in my estimation, I believe this does create a positive ethical duty on the part of RMTs to make a report against a fellow registrant under certain circumstances. And so if, for instance, you're informed by somebody that a fellow registrant has been abusing their mentally impaired elderly father, then in my estimation, you have an ethical duty to report that registrant under the Act, which in turn creates a positive duty to make that report under the college bylaws. Because in my view, that creates that ethical obligation. So those are the basic and the most, I think, the most straightforward obligations that create positive duties for you to report a fellow registrant for issues related to their professional wrongdoing. I think it is important, again, that I emphasize the importance to the integrity and the respect that the profession of massage therapy garners for each of the registrants of our association to take this obligation and duty very seriously. It is the first line of defense for your profession, and every profession takes their obligation to govern themselves and to maintain the standards of practice in their profession very seriously. And I think it would be a serious mistake for this profession of massage therapy to guard the integrity of the profession even one iota less jealously than doctors and lawyers and engineers do. They take their professional regulation and they take their professional integrity and they take their professional standards extremely seriously. And it is critically important to them and to the continuity of their profession, frankly, and the continuing respect that each of their professions garners, that these kinds of standards are maintained. And I would urge you to consider very seriously the circumstances in which you believe any of these obligations to report may arise. And again, I would urge you to seek the advice and counsel of more senior colleagues if for any reason you are unsure about whether you have a positive duty to report another registrant or not.